Okay. That's fair enough. All right, let's move on to criminal law for this week. So we're switching gears a little bit. Up till now, everything we've talked about has been civil law. And by everything, I mean just the torts that we studied for 2 weeks. But everything up to this week and then everything after this week will be civil law. And remember, civil law is basically everything that's not criminal, and it deals with rights between private citizens. It deals with the idea of tort law or civil law is to enforce our private rights, to compensate, to get compensation if we have been wronged somehow. Whereas in criminal law, these involve matters between the state and an individual or the federal government and an individual for breaking a criminal law. And the purpose of those is different. The purpose of criminal law is to prevent crime or prevent citizens from doing things that society has outlawed, obviously. It's to deter, it's to keep people from doing things. It is, in some cases, to rehabilitate the wrongdoer, the criminal. There's some debate about whether or not that really is even a valid goal of criminal law or not, or whether it should be. But it's a whole different ballgame. So in a criminal case, the plaintiff is always going to be the government. It'll either be the state or the federal government, or in some cases, could be a local government, I suppose, if you've broken a local criminal law. And then the defendant in those cases will be the person that's accused of the crime. Another big difference is that in civil law, remember, to win a civil case, you just have to prove your case by a preponderance of the evidence. And we talked about that means just really more likely than not, 51% to 49%. You can win a civil case. But in a criminal case, the burden of proof is beyond a reasonable doubt. And that is because the stakes are higher in a criminal case. We don't want people losing their liberty or in some cases losing their life based on any doubt about whether they're guilty or not. So beyond a reasonable doubt, what that means is that if there are reasonable explanations for the crime other than that the defendant did it, then the jury or the judge should acquit them or find them not guilty. So it's not beyond, it's not 100%, it's not beyond a shadow of a doubt, it's beyond a reasonable doubt. Beyond a reasonable doubt. And that means different things to different people. Should always be careful of your jury. But that's just kind of where we're moving into this week. So criminal law versus civil law. You'll hear about different classifications of crimes like felonies and misdemeanors. Felonies are generally more serious crimes. Well, not generally. Felonies are more serious crimes, and misdemeanors are less serious crimes. It depends on the state you're in as to where they draw the line. Typically, it's that felonies are punishable by jail time of a year or more. And if something is punishable by jail time of up to a year, that's a misdemeanor, or less, obviously. But again, it depends on how each state or jurisdiction defines their felonies and misdemeanors. You'll hear about different degrees of a crime, like third degree, first degree, second degree, all that. Those are just different levels of the seriousness of the crime. Whereas like first degree murder might be like cold-blooded, premeditated murder. Second or third degree might have an element of maybe there wasn't totally premeditated, there was some accident to it or something like that. So it's just in levels of seriousness. Sometimes it depends on what kind of weapon was involved, things like that. You don't need to know that for your test, but just that's a question I get a lot. Criminal liability. In order to be found guilty, you have to find two major things. One is there has to be a guilty act. And your notes call that the actus reus, just the Latin term for guilty act. You have to have done something wrong. And then the other thing you have to have in criminal law is a guilty mind. And the Latin term for that is mens rea. What is the state of mind that's required for this crime? So each each statute that defines a crime is going to tell you what kind of mental state you have to be guilty of that crime and what the actions are that you have to have done or not done to have committed that crime. So you got to have the act and you got to have the state of mind. Now there are different levels of that as well, but let's save that for just a second. Sometimes you can have a crime even if you don't complete the act, like attempted murder is still a crime. The act in that case is the attempt. Attempted robbery can still be a crime. And then there are some things that you do where the actus reus is an omission. Like, I didn't do anything. The crime was that I didn't do something, that I didn't act. Like, we're required to file tax returns. So if I don't file a tax return, that's the actus reus for the crime of not filing your taxes. That makes sense. So what constitutes the wrongful mental state or the mens rea? There are going to be different levels of that. One is just straight up intent. Obviously, if I had the intent to kill somebody and I did it, the state of mind for murder is intent. I intended to do it. So there are a lot of crimes that just require that I intended to cause the harm or do the act that I did. But criminal liability could also be based on recklessness. So I didn't mean to do the exact act, but my conduct was reckless because it was a conscious disregard for a substantial risk. I detonate dynamite in the parking lot. I ain't trying to kill anybody, but I have now created, by doing that, I have created a substantial risk of harm that I should know better. And so that's reckless conduct. So criminal liability can be based on recklessness. Like drunk driving can sometimes be reckless conduct. You didn't intend to have a wreck, but your conduct in driving while inebriated was reckless. It was a disregard for a substantial risk that you should know about. There's also criminal negligence. So remember in tort law, we talked about the tort of negligence itself, which was where we have a duty to act with care in everything we do. If you breach that duty, then you may have committed a tort in civil law. Well, some criminal statutes just require negligence as the mens rea, as the guilty mind part of the criminal act. Criminal negligence would be the deviation from a standard of care, just like in normal negligence, but it is it creates a foreseeable risk of substantial harm. Basically, it's the same analysis we would use for civil negligence. It's just that what we've done is the type of conduct that society thinks we need to attach criminal penalties to. I'm trying to think of a good criminal negligence example. I leave a loaded gun out and my kids get it and it accidentally goes off and somebody gets harmed. I have a duty to not leave loaded guns around where children who don't know how to use them can get them. So I was negligent in that way. And that negligence, we would say, was criminal in that sort of situation. So it's much like the tort of civil negligence. There's also some criminal negligence that could apply. There are also some crimes that bypass the mens rea or the criminal intent, and we just impose strict liability, meaning it doesn't really matter what you intended. Statutory rape is one of those. You have sex with an underage person, doesn't matter whether you intended to or not, that's going to be a crime. So again, there are different levels of the motivation or the intent that you might have to commit a crime. At the very highest level, again, is intent. I meant to do what I did. At the other end of the spectrum is strict liability. I had no intention of doing what I did, but the law says that if you do that, it doesn't matter what your intent was, you're going to be criminally liable for it. And in the middle, we have different levels of carelessness. Recklessness is conscious disregard for an obvious and substantial risk. And then criminal negligence, which is the disregard of a duty we have of care to others. Again, what you need to understand about that is just that criminal liability attaches based on different mental states. And what will determine what mental state is required for a certain crime, that's spelled out in the statute itself. It's not anything you're going to have to guess about. I mentioned that there are federal crimes, meaning that those are violations of laws passed by the United States of America. And then there are, of course, state crimes that are violations of laws passed by each state. And you could have local crimes too. Corporations can be criminally liable for the actions of their employees if they're acting within the scope of their employment or they're acting as an agent for the company. So we don't let companies off the hook for polluting or stealing just because the employees did it. The company can still be liable for that. Just going into types of crimes for a second. This is section 3 in your outline. You'll all be familiar with just the category of violent crimes: murder, sexual assault, assault and battery, robbery. These are the ones that we typically see that are classified by degree of seriousness, like I was mentioning before: first degree, second degree, third degree. And depending on what type of intent was involved, what kind of weapon was involved, what the level of the victim's pain and suffering was, those are violent crimes. We have property crimes, which a lot of that is what we would call theft or destruction of property. So just like in torts, how we had different discrete different crimes with different definitions, different torts with different definitions, same thing in criminal law. Burglary, I always thought that burglary was theft, but actually burglary is generally defined as breaking into, unlawfully entering the building or premises of another. So whether you stole something or not, you could still be guilty of burglary just for breaking in. Larceny is a word you probably heard. That is in general. And again, it's going to depend on how each state defines it. So that's why we're talking in terms of general definitions. But generally speaking, larceny that's theft. That's when you wrongfully or fraudulently take something that doesn't belong to you. So what I hope you're remembering is that in torts, we talked about how the same actions could constitute a tort and a crime at the same time. So larceny is similar to the tort of conversion or trespass to personal property. Remember, conversion was taking something that belonged to somebody else and depriving them of the use of it. Johnny converted Rusty's decorations when he stole them off the roof and brought them to his property. Johnny also could be guilty of the crime of larceny in that situation because he took and carried away the property of another. We like to think that whenever these things happen, we like for the government to do their job and for the police to arrest the person and make them pay restitution, and that way we as private citizens don't have to handle any of it. But that doesn't always work that way. Sometimes the police aren't interested in prosecuting a crime or arresting someone. Sometimes it's just not a good use of their resources. So sometimes we have to take matters into our own hands and use tort law to recover instead of criminal law. And sometimes there's both. Remember, this is how O.J. Simpson was not guilty of murder, but he was liable for wrongful death. Because murder was the crime that the state of California charged him with, and the jury found him to be not guilty. But the family of the victim sued him in tort law for the tort of wrongful death and they were able to recover from him under that tort. So same actions can have consequences in both civil tort law and criminal law as well. Obtaining goods by false pretenses, you've probably heard of that. If you defraud somebody out of their property, this is usually in the commercial sense. Usually applies to the illegal acquisition of funds or services, like stealing cable or stealing power. Things like that would be obtaining goods under false pretenses. It's also a crime to receive stolen goods. And most of the criminal laws that talk about the crime of a receipt of stolen goods talk about that you should have known, that you're guilty of this if you should have known that the goods were stolen. So it would not be a good defense if you were buying something out of somebody's trunk on the street that is valuable and that this person would normally not be dealing in. That might be enough to impose criminal liability because you should have known that those goods were stolen, receiving stolen goods. Arson, you're familiar with, that's burning down a building or property of someone else. Sometimes it can be personal property, not just a building. Forgery is another common one we're familiar with, the fraudulent making of any writing that changes the legal liability of another. So signing a check, signing somebody else's name to a check, signing somebody else's name to a deed, signing somebody else's name to a contract. Those are all examples of forgery. Those are property crimes. We have public order crimes, which are just generally against the peace of society. Those would be like public drunkenness, prostitution, gambling, drug use. Those sort of things are known as public order crimes. You've heard of white-collar crimes. Those are crimes that are committed within a legitimate business operation. So the business itself is legitimate, but some of the conduct that's going on within it is illegal. Those are white-collar crimes. Embezzlement is one that you should be familiar with. That's when an employee converts the property or money owned by somebody else to their own use. It could be that the employee is stealing from the company, or it could be the employee is stealing from a client. If we recover some money in a case that belongs to a client, and that money goes in my trust account, and I'm supposed to pay that money out to the client, but instead I make that check out to myself, or my assistant makes that check out to herself, that could be embezzlement. Speaking of embezzlement, this is another gripe I have. I meant to mention this to y'all. Does anybody watch or listen to, the Murdoch Murders podcast? No one? Damn. Well, I'm into this podcast. Y'all, has anybody heard about it? Okay, it's really good. It's totally interesting. And here's the 5-minute backstory on it. This family in South Carolina Low Country, outside of Charleston, rural South Carolina. Their family had been lawyers and involved in law enforcement for 100 years, going like dad's dad and his granddad and all that. And and they're kind of one of those like good old boy network, and they had just sort of gotten to do whatever they wanted to do for all these years because of who they were. And they're the most recent, I guess, generation of the family is a guy who's like 50, and he has 2 sons who are like 24 and 20. And the younger son was drunk and wrecked a boat into a pillar on a bridge, and it killed a girl they were all drunk and they were riding. And anyway, that was like what started the undoing of this family, because then they got sued, and then in the lawsuits they started doing discovery, and they started digging into the family's finances. And what they ended up figuring out was that the 50-year-old guy, he had been stealing from his law firm like millions of dollars. He had been stealing from clients, and everything in the case is fishy. Everything is fishy. he had this housekeeper that had raised his sons and been with them for years and years and years, and she tripped and fell and died. And he worked it out where he was like, okay, to her sons, y'all go to this lawyer. He's going to sue me, and I'm going to get my homeowner's insurance to pay the full amount out. I'll tell the insurance company that my dogs tripped her, which that was his story. My dogs tripped her, she died. So that's what happened. And the insurance company ended up paying up like $4.5 million. And the guy stole all of it. Like the family of the housekeeper never saw any of it. So all this is coming out. And then the guy's wife and younger son, the one that was in the boat wreck, they were murdered last summer in cold blood at their hunting land on the coast of South Carolina. And then a couple months after that, this dude, the 50-year-old dude, tried to fake a suicide or stage a suicide because he wanted the remaining son to get some insurance money or something. And then it went wrong, failed. So then he got arrested for that. And now he's been in jail for over a year now, and he's got like 100 charges of all kinds. I mean, they've figured out all that he was doing, and he got kicked out of his law firm. He lost his law license. A whole bunch of other people have gone down with it too. Like there's some people at the bank that were involved, and he's been charged with murder of his wife and son. And this is just a whole shit show of stuff. But the story is fascinating. But my gripe this is why I wanted to know if anybody's watching. The person who does the podcast, she's a great journalist. She has been bird dogging this story for like 3 years, and she's responsible for digging up a lot of this. But she has the most annoying voice of anybody I have ever heard. And I'm almost ready to quit the podcast because I just don't know if I can take it anymore. Anyway, that's my 5 minutes on that. It is really good, Nikki. But it might be better if you just read like what's happened about it rather than listen to her podcast because it's long. Yeah, it's kind of dramatic. And then the lady's supposed to be like an independent journalist, but she is out to get these people. And I understand that, but she'll say a lot of stuff that you're like, all right, come on now. I mean, that's probably true, but I don't know. She just talks like the guy's already guilty and she's already, I don't know how to describe it, but I feel like she's losing her objectivity. That's what I'm trying to say. That she's been doing it so long that she's just out to get these people. And so I don't know. She better be watching her back too, because that family is scary. But anyway, if you're into that sort of thing, it's a really good podcast. Murdoch Murders podcast, but it's spelled Murdaugh, like Murdaugh, but in the low country of South Carolina, they pronounce it Murdoch. Crazy. So where were we? Mail and wire fraud. You've heard of that. Hopefully, that's if you use the mail to commit fraud. That used to be more common than wire fraud. Now wire fraud's more common because it involves any sort of electronic means of fraud. So fraud by email, telephone, anything by electronic means is wire fraud. Bribery. You can have bribery in a couple different contexts. You can have bribery of public officials, which we typically think about. You can also have commercial bribery, where we're bribing, you'd be bribing somebody from a country to give you a contract or to buy your product through kickbacks and stuff like that. Interestingly enough, to be guilty for bribery, you just have to have offered the bribe. It doesn't have to have been accepted. So if I try to bribe the mayor this afternoon to get me out of my stop sign tickets, then I could be guilty of the crime of bribery, even if he doesn't take me up on it. We have a law called the Foreign Corrupt Practices Act that discourages bribery of companies from other countries, which makes the playing field a little bit difficult because in some other places, and if you're cynical, you could say it's in the U.S. too, but in some places, bribery is like a part of doing business. You're supposed to pay off the government official in this place because that's just how it's done. You do that in order to get in the game, so to speak. But that is illegal, even if you're doing it in another country. Bankruptcy fraud, it's illegal to declare bankruptcy or to use bankruptcy to shield yourself from your creditors in a fraudulent way. And that happens sometimes. Theft of trade secrets. It is illegal to steal the private business information of another company. And those can be pretty serious fines and sanctions if you do that. Insider trading, this is what Martha Stewart went down for. Our whole financial system is premised on there being an equal availability of information to all investors so that everybody's on a level playing field. Because it wouldn't be fair if some people had knowledge that a company had a product that was about to explode or had a product that was going to come out that it causes cancer and their value was going to drop precipitously. It's illegal to trade stocks or give out information on based on information that's not public. That's insider trading. Keep in mind too, in order to be guilty of insider trading, you don't have to be a member of the company. I could overhear somebody talking at a baseball game who's a executive of company X, and they're talking about how they've got this new product that's about to explode, and or a new drug, miracle drug that's going to cure cancer or something. And then if I go and buy stock based on that, I could be guilty of insider trading because that was not publicly available information. Now, we could have an argument about that, right? I mean, I didn't eavesdrop on anybody. I didn't wiretap. I didn't record somebody's conversation. I was just sitting at a baseball game and somebody happened to be talking loud. That might be a good defense. I don't know. I wouldn't want to try it, though. Just be careful if you ever have any inside information. Organized crime, this is the mob, the mafia. This is fought in a number of ways. Something that's often associated with organized crime is money laundering. That's where you're engaged in an illegal activity, but you are taking the money that you earn from the illegal activity and you are laundering it, washing it through a legal business. So if I run a pizza restaurant, but I'm also dealing cocaine out of the back door, and I'm taking the cash that I get paid for my Coke, and I'm putting it in the cash register, and I'm ringing it up as pizza sales, that's money laundering. I've cleaned that money, so to speak. Racketeering. Racketeering is basically, the general idea of racketeering is that a person or an organization is committing multiple crimes at the same time. And it was geared toward mob and mafia activity. The racketeering laws have been a little bit more broadly applied to individuals outside of the organized crime area. But the general idea of racketeering is you're engaged in some pattern or a group of criminal activity rather than just an isolated event. That's racketeering. There's also, this is not in your notes, but it's also a crime to conspire to do an illegal activity. And so conspiracy generally just requires more than one person working together to achieve a crime. And a person could be liable for conspiracy even if they're just on the planning, on the front end of it, but they didn't actually get involved in the carrying out of the crime. The conspiracy has a really long reach and can envelop a whole lot of different people if you're planning on doing something illegal. Skip over in your outline. Section F, cybercrime. I'm not going to talk about that or test you on that. Capital letter F, and it goes all the way through the Computer Fraud and Abuse Act. Not going to ask you about that. We'll skip next to Section 4, which is defenses to criminal liability. So just like in tort law, we had some defenses to conduct that might be tortious or that might involve some sort of liability for torts. There are defenses to criminal liability too. One of them that we know all too well, or that we're familiar with, is self-defense. The justifiable use of force. That differs by jurisdiction. You have a discussion question for this week based on a recent Florida interpretation of what a person can do to defend their home. So the question just involves kind of what you think about the way that, what'd you say, KK? It involves self-defense, though, right? Yeah, I thought it did. It had a lot to do with self-defense, right? Okay, so your question this week has to do with that. But generally speaking, and again, it's going to differ by state, but generally speaking, people can use the amount of force that's reasonably necessary to protect themselves, their dwellings, their property, or others to prevent the commission of a crime. Deadly force can sometimes be used. That could be a defense to the crime of murder. If there's a belief that there's a reasonable belief that there's imminent death or great bodily harm that will result if the attacker is using unlawful force. There are lots of different factors that could be involved. But you do see, hopefully by now, anytime we get into defining something as reasonable, that's going to depend, right? It's going to depend on the circumstances. It's going to depend on the location. It's going to depend on the values of that particular community. It's going to depend on the jury, the experience of the jurors, what their beliefs are about that. So anytime we get into definitions about what's reasonable, that should make us very scared. Necessity is a defense, and that would excuse liability in a criminal sense if the criminal act was necessary to prevent an even greater harm. So if I'm walking down the street and I see a fire inside a store, and I take a crowbar and I bust down the plate glass window to get inside to put the fire out, then necessity could be a defense if I were charged with the crime of burglary, which is breaking and entering into the property of another. I've met the definition of that, but I have the defense of necessity. Insanity is a defense. If you are not able to appreciate, your actions or the consequences of your actions, again, this is a really gray area as to whether or not somebody could appreciate what they were doing at the time. Mental illness is not always linear. It's episodic sometimes. I mean, somebody might be out of their mind at 1 minute and perfectly fine the next. So the insanity defense, if you're planning on committing a crime, I would not bank on that one. That's a really difficult one to prove. Mistake, interestingly enough, mistake can sometimes be a defense to a crime. My backpack looks the same as Lexi's backpack, and on my way out, I grab that backpack thinking it's mine. It wasn't mine, but I truly thought it was. That was a mistake of fact. I thought it was mine, but in fact, it was not mine. Mistake of fact. That can sometimes be a defense. Okay? Not always, but sometimes. But what it goes to is all these defenses, if you'll notice, the common thread between the defenses is that they all go to the state of mind. They negate somehow the mens rea, or the criminal mind, the guilty mind. Insanity negates it because you were out of your mind. Necessity negates it. I couldn't have had any criminal intent because I was doing something good. My actions were for the greater good. Justifiable use of force. I didn't have the intent to commit a crime. I'm defending myself. All these defenses negate, to a certain extent, they negate the mens rea or the guilty mind requirement. The act is still there, but the mental component of that element is not there. Here's something to be very careful of. Mistake of fact, like I said, can sometimes be a defense. Mistake of law is never a defense. So I could be mistaken as to that I thought it was my backpack, but I can't be mistaken as to whether or not it was against the law to take something that belongs to somebody else. It's not against the law. It's not a defense to say, I thought the speed limit was 55. That's not a defense. So that's a mistake of law, not a mistake of fact. We're presumed in all jurisdictions to know what the law is, even though there's no way truly that we all know every law at every place that we go, but you need to be aware of that. And when you do business in other places, just because you didn't know something was illegal in another country or another state or another jurisdiction, that will not absolve you of the criminal liability. So mistake of fact could sometimes be a defense. Mistake of law is never a defense. Duress is a defense when someone's under pressure. They acted not out of their own will, but because somebody forced them to. That again, that would negate the guilty mind requirement. Generally speaking, duress would be defined as excusing a crime if the defendant reasonably believed in the immediate danger, that they were in immediate danger if they didn't do the act. If a big, huge, scary person who's bigger and stronger than me holds a gun to my head to make me forge a check, I could use the defense of duress. But if a child came in here and threatened to beat me up if I didn't sign my name to my check, that might not be reasonable. My fear might not be reasonable. Might not be reasonable that I felt like I was in danger if I didn't do the criminal act. So duress has to be that you reasonably believe that you were in some sort of danger. Entrapment, that's when the government tricks you into committing a crime. Sometimes you'll see that like with prostitution. The prostitute propositions the client. It wasn't the client who approached the prostitute. That's an example of entrapment. I wasn't trying to hire a hooker, Your Honor. The hooker hired me. I was entrapped, right? I wouldn't know that. I feel like that's something you just see on TV. Yeah. I feel like, I don't know this, but I feel like that police don't spend much time on vice stuff anymore. I mean, some of that stuff, the argument is that don't waste your time and resources on something that doesn't have victims. Now, we could argue about whether or not some of these sex workers are victims and society is a victim and so on and so forth, but there's a prevailing thought that we're just not going to spend our resources on that when we've got limited resources as is, and we, like in Columbus, we have a murder problem. We have a violent crime problem. I would much rather our police be focused on the violent crime than on prostitution, personally. Is it entrapment? Yeah, that's entrapment. If the hooker comes to you, that's entrapment. Yeah. Now, I mean, if you're riding down the street, we're getting in a rabbit hole here. You're riding down the street in an area where you know hookers are, and it's 3 a.m. and you're by yourself and you're carrying a bunch of cash and you don't have any better excuse for what you were doing there, then that might not be entrapment. Okay, but if you were just at a bus stop, because that's a legitimate stop on wherever it is you're going, and some hooker propositions you, it could be entrapment. It could be. Statute of Limitations is a defense. So sometimes in criminal statutes, they will say that this is only good for so many years. After this many years, even if you did it, you can't be prosecuted for it. Statute of limitations. There's that. A lot of crimes have statutes of limitation. That just after a certain amount of time has passed, you're good. Murder has no statute of limitations. There's never any period of time that can run out where you would no longer be charged with murder. But most other crimes have a statute of limitations. Some of the more serious violent crimes don't. Yes, sir. State. Well, federal crimes will have their own statute of limitations, and state crimes will too. And they'll be different depending on the crime. So yeah, it depends on which jurisdiction you're in. All right, let's move over to, because I do want to finish this today. What time is it? 10:22? Okay. All right. Well, if I don't finish this, we'll just have 5 more minutes left on Thursday. So constitutional safeguards and criminal procedures. I'll tell you what, we're going to talk about this on Thursday because that goes with our case that I want you to read for Thursday, Carpenter versus the United States. And then I also put up some Georgia criminal statutes for you to look at. So on Thursday, we're going to talk about constitutional safeguards and criminal procedure. We'll talk about the Carpenter case, talk about the Georgia statutes, and then anything else that y'all want to talk about. I think that's a good stopping point for today. Anybody have any questions? No questions. All right. See y'all later.